Good morning, everyone, and happy Friday, October 7th. I would like to call to order the meeting of the Human Services Background Study Eligibility Task Force. And given the size of the group, I'm going to give Mr. Vogel the opportunity to do the roll call.
Thank you, Madam Chair. Ms. Basham.
I am here.
Thank you. Senator Champion. Senator Champion. Ms. Dawson. Ms. Dawson. Mr. Esme.
Here.
Thank you. Ms. Evans.
Here.
Mr. Geffen. Mr. Geffen. Mr. Hanson.
Clear.
Ms. Huntley.
Good morning, present.
Good morning. Mr. Urban.
Present.
Thank you. Ms. Kaser. Ms. Kaser. Mr. Kammer.
Present.
Lieutenant Knotts.
Present.
Judge Kulik. Judge Kulik. Senator Matthews. Senator Matthews. Ms. Mattson.
Here.
Representative Moeller. Representative Moeller. Inspector General Modi.
Present.
Mr. Page. Mr. Page. Ms. Robertus.
Present.
Representative Robbins.
Present.
Mr. Sandoval.
Present.
Judge Satterback.
Present.
Ms. Sherlock.
Present.
Mr. Tatum. Mr. Tatum. Ms. Williamson.
Present.
Thank you, Ms. Williamson. All right, Madam Chair, we have 16 of the 25 members present. A quorum is definitively present.
Awesome. So with that, thanks everybody for being here. Getting to the end of this, we appreciate you all making time for this. Let me get back to the agenda now. With that, we will note a copy of the September 23rd meeting minutes have been posted to the task force website. And if there's any corrections, now would be the time to mention them. With no mention of corrections, we will adopt the September 23rd meeting minutes. Thanks, everybody. So today what we're going to do is kind of go over the recommendations from each of the subcommittees. And the idea is that then folks that have been like appointed from the governor's diversity, equity, and inclusion group, people from the county attorney's office, our legislative representatives can kind of bring these like preliminary recommendations back to those groups, and then kind of find out where folks are at, and then we can come back and talk about that and kind of decide what we're going to do for like final recommendations before we start writing, instead of getting to the Capitol later with recommendations and finding out then that there's problems. And so what we're going to do today is have each subcommittee share their recommendations, like preliminary recommendations, and then on Tuesday we will have our final recommendations from disqualifications, and then people can take those back to their respective groups and get some feedback. So that's kind of the plan for today. And we'll start. Does anybody have any questions? Okay, and then we'll start. Josh is gonna talk about the remedies subcommittee activities. And do we have a time frame for each? Not really. We have plenty of time, right? Well, okay. All right, Josh.
All right, I'm gonna try to get my screen share working here. Okay, everyone see this okay? So I'm gonna apologize in advance if this presentation isn't quite as polished. I've been in trial this week, and our subcommittee chair, Lucas Dawson, is also in trial this week. So we were kind of scrambling yesterday to figure out who was going to go through the presentation. So I'll give it my best shot. So just sort of as a preliminary matter and as a reminder, this was kind of the scope of our discussion. We're, the remedy subcommittee, but we had taken on a few things that were sort of related both on the front end and the back end remedy stuff. So we ended up looking at the permanency disqualification issue, the preponderance of the evidence determination issue, and then did a sort of a dig into the process for suggested changes that could make the process more efficient and more user-friendly. This is the outline of our discussion. So the first issue that we ended up tackling was the permanency. And we're sort of looking here at kind of two related issues. One is going to be the list of offenses that create a permanent disqualification in the first place. And then sort of related to that is the bar to a set aside that applies for those permanent disqualifications. And the kind of the strategy that we looked at going into this was really to start with what stuff was out of the state's hands here. And what I mean by that is that there are a couple different federal laws, most notably the Adam Walsh Act, that it themselves had requirements that there be permanent disqualifications, at least if the state was going to be receiving federal funding for those programs. They mostly have to do with adopting in foster care and other childcare related activities. And so what we ended up sort of settling on as our group's recommendation is that the permanent disqualifications be sort of as narrowly tailored to that compliance as possible, with a couple set asides. So kind of the first thing is that anything that is sort of required by the Adam Walsh Act is going to stay a permanent disqualification, but that would limit both the offenses that trigger the permanent disqualification and also the types of jobs or positions or opportunities that people are applying for that trigger the background study. So it would just be narrowly tailored to those jobs that trigger federal compliance and the specific offenses that are listed in those federal statutes. Everything else, save for a few exceptions, would not have a permanent disqualification anymore and would sort of default. If it had been a permanent disqualification before, we sort of just anticipated that it would default to whatever the longest disqualification period that the disqualification subcommittee comes up with. So then I didn't know that there were going to be a few exceptions. And for that, we actually borrowed upon the work of a previous task force, the 2008 task force that looked at this, recommended that permanent disqualifications be limited to murder, manslaughter, and felony level criminal sexual conduct. And so we thought that was a good place to draw the line and agreed with that. I put here in parentheses because I seem to recall that we did though anticipate that it wouldn't be a permanent bar to a set aside, that somebody even if they're facing a permanent disqualification length for a murder, if at some point they are able to come back, maybe 30 years later, and show DHS that they have rehabilitated to the point that is safe for them to work, they would get a set aside. So I think we anticipated removing the permanent set aside bar. But I put that in parentheses because Will put together this PowerPoint from past notes and that wasn't on there. So I'll try to clarify that and get back to everybody. And then further, we suggested removing permanent disqualifications altogether for others, for a subset of jobs that people are applying for. So in particular, those that go to substance use disorder related positions, and facilities, and then family caretaker positions. So what we mean by that is positions where someone is applying to be compensated through DHS for providing care to their own family member, taking care of a elderly parent, something like that. The rationale being that in that situation, there's no change in that person's level of access to the family member. So it doesn't make sense to have a permanent disqualification that would, prevent them from, getting compensation for providing that work for someone whom they already have access to anyway. And then the last one is removing permanent disqualifications for any conduct that was engaged in by a juvenile. And then a fourth one, removing permanent disqualifications for positions that do not have direct and unsupervised access to vulnerable people. Any questions about that before I move to the next issue? All right, seeing none, we'll keep rolling. So the next issue that we were looking at was this issue of disqualifying people based on a determination that there was a preponderance of evidence that they engaged in the conduct that would have violated the elements of the criminal statute. And that is opposed to a disqualification based on a conviction or some other court finding that the person was guilty of the thing they had been accused of. And the strategy that we took in looking at this issue was really to try to compare Minnesota to most other states. We had a law student, summer intern, who was working with me at the Legal Rights Center, who did a great job doing kind of an exhaustive list. Well, actually, no, I should give credit to him, but I should also give credit to Will, because Will did a lot of that work as well. Kind of going state by state and pulling the analogous statutes in those states, statutes that were designed to protect vulnerable people, and looking to see, frankly, if anybody else was disqualifying someone based on evidence that was less than a conviction. And if I recall correctly, I don't think there are any other states that do it. Maybe there were one or two that I'm forgetting about, but it was exceedingly rare in the scope of our neighbor states to be disqualifying people based on this low of an evidentiary standard. So our suggestion is that we get rid of the preponderance of the evidence determination altogether, that disqualifications only be made on convictions and on stays of adjudication. So a stay of adjudication is going to be a disposition that sometimes happens in criminal court, where somebody usually pleads guilty. In some narrow cases, it could be that they're found guilty after trial, but almost always they plead guilty. And as a part of the plea bargain, the judge agrees to stay the adjudication of the crime. That means that they don't pronounce them guilty based on that plea. The way I usually describe it to a client is they take the plea and they put it on a shelf and they put you on probation. But then once you complete probation, they take that plea that they've been hanging on to and toss it out, and the case ends up getting dismissed. So stay of adjudication avoids a conviction altogether and ends up with a dismissed case if the person is successful. But it does still require the person to come into court and offer a plea to the court, admit that they did the act that violates the criminal statute. So it made sense for us that would still satisfy the level of evidence that we'd want to see before a disqualification happens. And that's similar with other states. That's what the Adam Walsh Act requires. There's one other issue related to the preponderance of the evidence that we looked at, which is doesn't come up for criminal charges, but comes up when there are findings of serious and recurring maltreatment that is usually done at the county level by like Child Protective Services. And this particular area is not my expertise, but Chair Dawson from our subcommittee knew this area very well. And so I'll try to summarize what our recommendations are here. So one of the things that made sense to the group after Chair Dawson presented to us was that family assessments would not be used to calculate whether maltreatment is recurring. And a family assessment, to my recollection, is sort of a very preliminary investigation that like a social worker will do when there's some kind of complaint, but it's sort of like the first step of the process, and is often not very thorough. There's no opportunity to challenge the findings at that level. And so what we'd want to see is that family assessment then sort of gets passed into the system. And if the county decides that there, based on the assessment, that there needs to be a more sort of formal intervention investigation, then they do that. And so what we'd want to see is for it to at least get to that next level at the county before information could be used as the sole basis for a maltreatment finding. We also suggested that hearings should always be available for disqualifications based on serious and recurring maltreatment, even if the individual did not appeal the maltreatment at the local level. And so kind of the idea here is that, people often will sort of just work with the county to get the help that they need, and not, fight tooth and nail about, whether or not what they did sort of meets the legal standard for maltreatment. And then sort of, if they do that, they might not be realizing that they are losing an opportunity, to fight whether or not that maltreatment could have been substantiated in the context of employment in a DHS background study. So that suggestion is just sort of to make sure that people always at least have the opportunity to be heard before they lose the ability to be employed. And then at that hearing, the department would have to prove the maltreatment by clear and convincing evidence, so not preponderance of the evidence. And the individual may still challenge the underlying maltreatment even if no appeal was done at the local level, or was upheld at the local level by a preponderance of evidence at a fair hearing. Any questions about any of that before I move on?
Just want to add with the family assessment clarification, when a screening has been done for child protection, the investigator can go out and either investigate for a child protection case or do a family assessment, so-called, to offer resources for the family.
Thank you, I appreciate that. Like I said, this is not my area of expertise. Anything else from anyone? All right, so the third main bucket that we looked at was related to the actual process of applying for a set aside, or requesting reconsideration, which could include either applying for a set aside or challenging the correctness of the agency's determination to disqualify you. Although in our sort of anticipated process going forward, if there is no preponderance of the evidence challenge, then the main issue that we're going to be thinking about for this process is going to be the request for reconsideration. Sometimes there are other, sort of clerical mistakes. Like it's possible that, if there was an issue with like a stolen identity, that, person A might have a disqualification for conduct that was actually engaged in by person B. That would be the type of thing that would, you'd still want to request, reconsideration, but not a set aside. But I think for the most part, the bulk of the cases coming through the process right now are either challenges to the preponderance of the evidence determination or set aside requests. And if we're getting rid of the preponderance of the evidence determination, then most of this would apply just to the set asides, though, of course, if the whole group doesn't agree on getting rid of the preponderance of the evidence determination, then some of these process recommendations would apply to that kind of issue too. So the first thing we looked at was the timing to get the appeal or the request for reconsideration in. And under statute, that is either 15 or 30 days we thought it made more sense to keep it simple, have it be 30 days for everybody, limit confusion. 15 days is also oftentimes a very fast turnaround for someone to get in. We also would suggest that we codify a good cause exception. So if someone gets their request in outside of the period, but can provide a good explanation for why they missed that deadline, they got really sick or they didn't get the notice on time or whatever it is, that there be some flexibility around it. There was a suggestion that the notice go out by certified mail, or possibly even personal service if certified mail isn't possible. And then there was also a suggestion that, and we sort of kept this one as a little bit softer, that DHS should look into doing this as opposed to suggesting that it actually happened, because we weren't really sure about the feasibility of it, but it does seem like a lot of these types of systems in the last decade or so have started to move to a more online focus with like a web portal where you can have your own access to information and be able to look up the status of things. So suggest that DHS look into that. The next issue we looked at is basically who's responsible for getting the police reports. Right now, the statute basically allows DHS to request any information that they think is going to be helpful from the applicant and the person requesting reconsideration. And then it's been my experience that one of the things that DHS often, or if not always, asks for is for that person to go get a copy of the police reports. And Gina could talk about this a little bit more from her personal experience, but that can be a very, very arduous task for people. It often involves going in person and getting them, which could involve traveling all over the metro or even all over the state. And especially if you're trying to do it within a condensed time period, it can be very difficult. And then, one of the things that another thing that we've seen is that once you get further into the process, DHS usually provides you with sort of discovery, the information that they have in their file. And it's almost always the case that DHS had their own access to the police reports at some point in the process anyway. So it seems like it makes the most sense for the agency to get the reports and provide them to the applicant. So that would be our suggestion. If DHS can't get the reports prior to issuing the initial disqualification, then we didn't want to hold up that process. So DHS would still be allowed to issue the disqualification, but we'd want to not put the person in a position where they don't have all the information that they would need to consider their appeal. So we would say that we'd suggest that the 30-day window from the previous bullet point not start tolling until DHS can provide the police reports. The next issue we looked at was the waiver of appeal rights. So kind of how it currently works is if you don't request reconsideration within the time period, you waive your right to request that reconsideration, and any of the agency determinations that were made as a part of that become final. That is not the end of the world if all someone is trying to do is get a set aside in relation to a particular job, because the issue is discrete there. It has the person shown that it's safe for them to work in this particular position that they're applying for. And if the answer to no is that, well, it still just applies to that one job, and the applicant could go to another job and start the process again. And it isn't that big of a deal that they waived that issue with the previous job. But this is a huge problem for the preponderance of the evidence determinations, because what happens there is you lose your right to challenge whether or not the agency was correct in determining that preponderance of the evidence existed. And that would then carry over and be an issue that was already settled and waived at the next application for the next job. So this is another one where if we're getting rid of the preponderance of the evidence determinations altogether, and frankly, the existence of this issue is one of the reasons we wanted to get rid of the preponderance of the evidence determinations. But so if we do get rid of them, then this is a non-issue. But if the large group decides to keep preponderance of the evidence determinations, then as a fallback, we at the very least would want to change the statute so that somebody doesn't waive that by failing to challenge it at any particular hearing instead, or failing to challenge it with respect to any particular set aside or request for reconsideration request. Instead, it would only be finally determined after a hearing. More process issues. One of the things that we're looking at is the response time after someone gets their request for reconsideration submitted. Now, by statute, there is language already that says that DHS has to respond within 15 days if it's a risk of harm assessment, 30 days if it's a correctness assessment, like a preponderance of the evidence determination, or 45 days if the applicant is raising both issues. But what we've seen happening, and this is a little bit anecdotal, but what we've seen happening is that DHS will respond, but oftentimes their response just says, we haven't been able to decide this yet. We're still working on it. We need more time. So that actually, to us, well, so a couple of things as we discussed this issue. One is we are hoping and anticipating that changes that come out of the disqualification subcommittee and removing the preponderance of the evidence issue from the landscape will already lighten the workload for DHS in a way that makes this less of an issue as it is. But to the extent that they still may have, times where actually deciding the issue within those statutory timeframes isn't possible, we've actually sort of figured that what DHS is doing is a pretty reasonable compromise. Still getting back to the person. DHS oftentimes, when they're doing that, will say that the person can work while this is ongoing. So it seems like the agency's sort of doing the right thing already. What we would do is just seek to codify that should continue to be what the agency does. So if they can't make the decision in the time frame, they should take steps to ensure the applicant can continue to work, and notify them within the time frame that that's what the current decision is. And then we did though think that putting some final limit on when DHS should get it done would be good, and we were suggesting 6 months. Another issue that we raised was what has been called traveling set-asides, which has been something that DHS has aspired to be able to do. At least from my understanding, it's been something that they've been wanting to do for a long time, but there are various difficulties that have been in place that have prevented that from happening. So again, here, this is a little bit of a sort of a softer recommendation. I think more work needs to be done with the agency to figure out exactly, how to make this happen. But essentially what we'd like to see happen is the agency set up some ability to grant set-asides that would apply to like a broad set of jobs and stick with the applicant instead of needing to trigger a whole new set-aside process connected with each employer, both to minimize work, create efficiency, and also give some assurance to the job seeker that the positive outcome they got the last time will be there the next time. We did some brainstorming about the accessibility of the process, especially for people for whom communicating in writing and in English is difficult. We'd like to create a process for the initial request for reconsideration to happen by an interview, something akin to how the violations bureaus at the courts have hearing officers. And then in addition to that, and kind of related to the web portal suggestion earlier, we think it would be great if DHS could make it possible to create submissions and to correspond directly with DHS officials via email. Right now, when DHS sends out a letter to people saying that they've been disqualified, they do a really nice job of explaining the rights to the set aside and reconsideration process. And also current, the most recent letters that I've seen have a list of community resources where people could get legal help in going through that process. I think that they include the Volunteer Lawyers Network on there. I think they put some of the legal aid organizations on there. We think that what the agency is currently doing is great and would like to see that codified as a requirement going forward to make sure that's always there. So last couple of issues. This is a little bit of a pet peeve, I guess, of mine that I put on here because it just has not ever made much sense. We are recommending that people remain disqualified for stays of adjudication, but that creates a sort of a weird issue where someone could get a stay of adjudication and end up with a longer disqualification length than somebody who got a different disposition, which is not as beneficial in the criminal law context, called a stay of imposition. And sort of the difference between these two is that with a stay of adjudication, there's no conviction entered and the case is ultimately dismissed. With a stay of imposition, there is a conviction entered, but the judge holds off on sentencing the person at the highest level available based on that conviction. So it often happens in like low-level felony cases, and instead puts them on probation, and kind of the carrot is that if they successfully complete probation, the conviction is deemed to be a misdemeanor instead of a felony. So it's not as good as a stay of adjudication because you are convicted, you're convicted of a misdemeanor, whereas with the stay of adjudication, you're not convicted of anything. But the way that the 245C15 is set up, the stay of adjudication would remain at the highest and longest disqualification length, while the stay of imposition would shorten to the misdemeanor, the shortest disqualification length. And so to correct that sort of nonsensical outcome, we would just recommend that the stay of adjudication also receive the shortest disqualification period, whatever that period ends up being from the disqualification subcommittee. There's a list of harm factors, or a list of risk of harm factors in 245C22 that is already very thorough and very good. We had one suggestion on that, which is that DHS should also consider the level of supervision and the frequency of access to vulnerable people formally within that risk of harm factors. This is another thing that in my experience, DHS is already doing and doing well. So this is sort of another, let's codify the good things that they're already doing recommendation. And then another issue that we talked about that sort of was related to the process issue was, are there any other ways sort of beyond just improving the accessibility of the process that we could improve the accountability of the agency to the community? And, I think, one of the things that we talked about here was the possibility of, bringing civil suits for, particularly egregiously bad decisions should they occur. But that is very difficult to do. It's difficult to sue a government agency. There's qualified immunity, all of that. So the ideas that we did brainstorm and want to put out there for the group's consideration is some type of attorney's fees system, sort of maybe based somewhat on how it works for someone who's applying for a conceal and carry permit, where if the person is later found to be eligible for the permit and had been wrongly denied. So in our case, if they're disqualified, end up going all the way through the appeals process to an administrative law judge or a DHS judge, and prevailing there, that there would be an opportunity then for that person to get attorney's fees. And then a similar suggestion is maybe lost employment income as well. All right. that was everything that we've been working on for the last year. Does anyone have questions or anything they want to talk about before I hand the floor off to someone else?
Great job, Josh.
Thanks, Gina. Take it away.
So that's a hard act to follow. Just gonna say that. Also gonna say I wish Josh was here. I mean, John was here. So, can you guys see my screen?
Yes.
Thank you. So disqualification subcommittee is not, we're not all the way done yet. We have one more meeting on Tuesday to kind of finish up the childcare foster stuff. And then we still need to get like our final recommendations for one of the sections. And so I'm just gonna go over what we already have, and you guys will just have to bear with me. Hopefully John will be able to be here next time, and anybody that is part of this group that wants to jump in, pretty please do that. So so the disqualification subcommittee was organized to review a list of criminal matters and to determine if there's areas in the law for improvement. We reviewed the law with paramount concern for health and safety of vulnerable adults and children. And we sought ways to simplify the law, reduce disqualifications for those that don't pose a risk of harm. And the things that we did, like the areas that we reviewed, were juvenile offenses, the length of disqualification for those offenses, the list of disqualifying offenses, and then the date the disqualification period should begin. And then also child foster care, which we're going to cover on Tuesday. So that's what we covered in. It was no easy task, and I'm not surprised that we need a little bit more time. So juvenile offenses, under the current law, they review juvenile offenses when conducting background studies, and they're required to use juvenile adjudication when determining if a person is disqualified. And so accordingly, a 14-year-old that's adjudicated for burglary, then they're disqualified for 15 years, the same as an adult, which seems unfortunate. Like, we've just determined that that's unfortunate. So the concerns we have is the Background Study Act treats juveniles the same way it treats adults, as a conviction. And Judge, if you want to jump in here, the way that the criminal court treats it, it's as an adjudication. And the way the background study treats it is as if it's a conviction. And that just doesn't seem just in this case. And so the brain science, according to maturity levels, says that kids mature as they get older, and we're holding them accountable for that behavior for a really long time. The racial disparities are, the racial disparities are stark with both adults and juveniles. I'll let you read that. I'm not just going to read to you. And then there's a policy 260B002 on disproportionate minority conduct. You guys are welcome to go back and look at that. The policy of the state of Minnesota is to identify and eliminate any barriers to race, ethnic, and gender fairness within the justice system. And then some juvenile matters are severe and require exclusion from vulnerable individuals, and we recognize that. So this is one of those areas where we're going to go back in and put our recommendation in, and we'll have that to everybody via email on Tuesday. But this is the stuff that we're looking at right now with juveniles. So one of the other categories was the length of disqualification. There's 4 categories: permanent, 15, 10, and 7. The permanent disqualifications are pretty broad and they go above and beyond. 15-year is all the felonies, 10-year is all the gross misdemeanors, and 7-year is all of the misdemeanors. So that's what we've been talking about over the time of the task force. Our concerns about our current system is that the disqualification periods are longer than other states. The racial disparities are very apparent. We've looked at the data. All of the data supports that. 15-year disqualification periods for drug possession are not consistent with public safety, and the longer periods are not necessary to maintain public safety. We also have noted, and we can show that data to y'all when we get a report together, that if somebody with drug substance use disorder issues are not working around drugs and have some length of sobriety and are working in an area that doesn't like, if the crime that they committed isn't aligned with the job that they're doing, why are we holding them to that for 15 years? It's too long. And it exceeds both the Adam Walsh requirements and the child care block grant requirements. It's also inconsistent with expungement statutes. We looked at the data, and people are eligible for the crimes that are in the expungement statute, oftentimes long before the disqualification periods are over. So, and the foster care licensing scheme was simplified as well. So they're not consistent. The changes that happened last year with child care foster licensing. So confusing, hard to implement, and the science does not support for recidivism and sobriety, any of that. So we had people come in and talk about that, and we can get that together for the report. So the recommendations that we're making is to eliminate the current structure for permanent disqualifications, and that these disqualifications are far too long and not commensurate with statutory need or purpose of protecting vulnerable adults, and have those align with what the feds are requiring. Replacement of a 2-tier system for 5 years and permanent, and that's what the feds with the Adam Walsh, and that's what AWA is, the Adam Walsh and the child care block stuff. So we're looking to align with that, and then to identify where it's consistent, where our recommendations are consistent and inconsistent with the 2008 report. Will's doing that work now. And then the work that the child care foster folks did, I don't know if it was last year, I think it was the year before, that would be consistent with the work that they did as well. And I don't remember what this 20-year termination of parental rights thing is. Does anyone else?
Madam Chair, I believe Mr. Page pointed that out as an element of the new child foster care statute, as somewhat inconsistent with the rest of that statute and inconsistent with the permanent and 5-year scheme that the group was working with. Essentially, voluntary or involuntary determination of parental rights is a 20-year DQ under that statute, as I understand it from his description.
Got it. All right. So the list of disqualifying offenses, they're all listed in the statute. Our concerns, including offenses that are not based on community safety. I talked about that, like the risk of harm between the job someone's going to do and their offense. That doesn't take that into the list of jobs someone's going to do in their offense having no correlation. Also crimes of poverty and property crimes, removes employer completely from making an informed decision. The background study law prohibits employers from hiring those that they think are best suited for the job. and many offenses not listed in the federal Adam Walsh or block grant. We're completely inconsistent with other states, especially around POE. And the laws that we currently have are not consistent with child care foster rules. Again, Will's going to look at what the differences are. So our recommendations is to, this is the date of disqualification period and when it should begin. Our recommendation is to use the date of offense as the date of the disqualification period begins. This ties to the conduct. This ties the conduct to the period of disqualification and assures equal treatment for all, regardless of the time it takes for the court to process the case. One of the things that we talked about is that it's the crime or conduct that we want the person to get away from, and to get away from. It's conduct that we're looking at. And when you're looking at court cases, people don't have a lot of control over when they get into court or how long it takes. Right now, the judge talked a lot about felony court cases are getting precedent or getting taken before misdemeanor and gross misdemeanor. And so there's cases that are gross misdemeanor cases that are getting pushed out, and the person doesn't have any control over that. And so for some of those reasons, we just, the one date that's always consistent is the date of offense. And so the one place that would make that really tough is if somebody gets committed to the Department of Corrections, and then maybe that would be the release date. Release from sentence. We are not unanimous in this, and so how we would work through that, we're still talking about. And another option would be to mirror the child care foster statute that they just came up with, which is some different points in time. So like I said, we're not done yet. We're still looking through it, but wanted to get y'all something today. So that's that.
Madam Chair, just to make a clarifying point. So the reason in this presentation there were concerns for the list of disqualifying offenses, but not specific recommendations, is the group's been working quite a bit on that and has been unable to really reach consensus on a specific list of disqualifying offenses to be removed or kept on in the statute. And the group's planning on working on that on Tuesday as well. So the juvenile offenses and the specific list, which are the two areas of recommendations that are kind of missing here. I believe the group hopes to have some recommendations on Tuesday.
Yep, it's been tough. It's been it's been tough. Everybody's got, I think, good points that they bring to the table about the whys and the whys not, and why not. So I'm confident we'll be able to get to something on Tuesday, and then also the any changes for childcare. So discussion of other subcommittee activities and other background study topics. So data analysis and data groups, anything from Roy, Mr. Kammer, or Ms. Williamson?
This is Roy, and I'll go ahead and jump in. I think one thing in terms of recommendations that I really saw coming out of the subcommittees is, from data analysis, we really support the continued collection of data and the analysis of data. We saw data appearing in each of the reports. And I think one of the things that we've chatted about over time is just the importance of collecting data, looking at data. As we've gone through this process, DHS has been great about working with us and been very transparent that a lot of the things we've been asking for are things that we're going to take a while to pull. So we'd really like there to be, a standardized process moving forward to continue to look at these data. We've primarily focused on 2018 and 2019. So, there's more data to come. when we take a look at data, when we think about data from this, again, very thoughtful perspective, it helps us to make more data informed decisions. I think what we've also talked about is keeping that data, public facing, so that, we as consumers are familiar with what this process looks like, so we can all continue to be informed and to be good advocates. So I'm so happy to see data reflected on in the prior reports, and we just, simply support that, we've enjoyed working on data, and we think it's important that there are processes and resources that allow this to continue to occur for this topic. With that, I will yield to others.
Wouldn't a dashboard be lovely?
Oh, a dashboard would be absolutely lovely.
Vice Chair Evans, can I jump in quick?
Absolutely.
Yeah, I just wanted to echo that is something that we didn't make it into our PowerPoint of recommendations, but something that we talked a fair bit amount in remedies to. And an idea we had was something akin to the annual reports that the Minnesota Sentencing Guidelines Commission puts out. Could be really helpful, and just, being able to have that archive then and go back and look at the year-to-year changes. I think a dashboard's a great idea too. But just to point out that these are some, that is a requirement that is being followed by other sort of analogous parts of the government analogous agencies. So I think there's something we could borrow upon to make that recommendation.
And was that in there? Was it in the?
It didn't make it into the PowerPoint that I just went through, but we
But
definitely
we put it in there. And so we should make sure to get that. Will, do you want to make a note of that so that we get that in there, some kind of report or dashboard, so that it's not this hard to get the information in the future?
Will do, Madam Chair.
Thank you. And then, so any questions, any comments, anything from anyone?
just good luck on Tuesday.
Yes. Oh, yeah, that too. Chair, I would like to just, Vice Chair Evans, I would like to say, yes, with the data subcommittee, we're very appreciative of all the data that DHS has provided to us. And also, just to second, that there's data we still have not received, whether it's just data that hasn't been regularly gathered, or there's no specifics of where to gather it from or needing to put it together. So being able to have some type of an annual report or dashboard would definitely be helpful.
Thank you, Ms. Williamson. All right. And then, so, Will, help me remember, so we're going to get everybody the 3 completed sets of, or the 2 completed sets of bullet points from the 2 subcommittees. I'm going to guess by Wednesday, because we want to get them in some kind of format that's easy to read. And then what was the date we were looking for feedback back from?
Madam Chair, well, first Representative Robbins' hand is up, but
I didn't see, it's yellow in your background and then the hand's yellow, so I can't see it very good. I'm sorry, Representative Robbins.
No, that's quite all right. I just wanted to ask that the PowerPoint that was shared would just get circulated to all of us so that we can, just make sure that we can really digest it. Thank you.
Thank you.
and I'll be sure to do that, Madam Chair, Representative Robbins. In answer to your question, Madam Chair, I believe the discussions I've been hearing suggested the next task force meeting of October 21st. Although I believe that might be, I believe there was also some discussion that might be problematic for some members with their home organizations. So the 21st, the next task force meeting after that is November 4th. But that sort of all segues to the scheduling question, which you see on the agenda there. So
Yep.
I suppose I'll drop it right there until we get to that point.
Yep. So I wonder then, so the question is, do we go to weekly meetings or right? Or do we change to like, because I think now, you know, the question is about, yeah, I guess I'd just like to have the conversation with the membership about going forward, like, how do we write this? How do we, you know, come to consensus or, yeah, I don't, are we gonna meet every week? Are we gonna change to different, like go, instead of doing the 21st, do we go to the next week and then start meeting every 2 weeks? Like, I don't know how to do this with scheduling. Cause we need to be done and start writing by when to be done by December 16th. How much time do we need to write it?
Madam Chair, I'm available to display a calendar actually, which might be helpful for this discussion. As for when we as for the writing schedule, I suppose just briefly, the final report's due on December 16th, and so sort of working back from there, ideally we'd want, I would say we'd want the writing to be wrapping up in like late November, honestly, because we're going to need time for the membership to review the final document and digest it and discuss it, vote on it, etc. And then on the administrative end, we're going to need to do some work behind the scenes to get that document together. So it's somewhat of a tight time frame at present. We're here on the 7th of October, and that's just over 2 months to get all this done. So,
And then 2 of those Fridays are holidays, right?
so that is an issue, Madam Chair. November 11th is Veterans Day, and November 25th is the day after Thanksgiving. So if the membership did want to move to weekly meetings, particularly in November, we'd need to find an alternate date to this Friday date.
Can I ask just a preliminary question? Are we anticipating having some like full adoption of the proposals before we start writing? Or do you want us to write up the proposals as they are and then use those last few weeks for discussions? I mean, to me, it kind of makes sense if we could do it to have a vote on adopting the subcommittee recommendations first, and then to send it back to the subcommittees to write up their sections and then meet again. And if we do it that way, maybe we actually could use the first couple weeks of December still on writing, because we would anticipate maybe less need for a really rigorous review if we had already agreed on the adopted recommendations.
That's
But
what
then-
I was thinking we were going to do. I mean, have bulleted recommendations and then putting the words and the fluff to it. Like you said, you could go up to the wire with that.
Yeah.
Not that you'd want to go to the last minute, but.
Yeah. That's kind of what I was thinking. Miss Basham, did you have something?
I did, thank you. I guess I would recommend that a work group or subgroup. I don't know if we're planning on, I hope we're not planning on doing these in the meetings. I don't have the capacity to meet weekly, if that's the proposal.
Yep, and we talked about that, doing a subcommittee to actually do the writing, because I feel like there's some folks on here that are just more skilled to be able to do that work. And so, yeah, Judge Soderbach.
My suggestion would be maybe we do this, since this is such a large group, and we're going to need a majority vote to get the recommendations through. I think you said next week you're going to be sending out them in writing. Was that next week?
Yeah, probably on Wednesday because we need one more meeting of disqualifications to get the final recommendations. Yeah.
So usually with groups this large, what you would do is you send it out in writing so that everybody can go back to their various groups and get input. And then if it's possible, I don't know how the documents are going to be shared or how you'd want to handle this, but normally you put your comments, that whatever questions you might have or disagreements on the document to back to the person who's kind of going to be or subcommittee or group that's in charge of that particular recommendation or proposal. Then that way they can see all of them. And then it should all get added to one document, shared with the group. We come back for a meeting so that we're not sitting in one meeting with everybody talking about their agreements or disagreements. That way everybody can see it ahead of time so that when we do come back to the meeting, we're simply discussing the comments that were raised, and then we have to have a vote. Otherwise, we're just never going to get through it in time.
And Madam Chair, sorry.
That was the only problem is either we have to have one document we could share and we could comment on, like a Google Drive. Otherwise, somebody has to go back through and then add those comments so that we can all see it.
Yeah, Will has a Google setup for that we've been using for other stuff. So I think that's a great idea.
Yeah, and Madam Chair, as you're probably thinking, with Google Drives, is there an open meeting compliance issue? But just to anticipate that question, Judge Satterback's plan sounds like it would be open meeting compliant because the public would be able to view the discussion of that document, and it would be posted for the subcommittee meeting that discussed it, and then if there is a subcommittee created, and then for the task force meeting that discussed it.
Is there any problem with that, Carol or Michelle?
None that I know of.
Okay, perfect. Great. So,
I mean, is it too optimistic to think that we could get that done in the next full group meeting?
Is that enough time? If we get it, that's like 10 days. So if we can get the document together with the recommendations from the two subcommittees by like Wednesday, that would give everybody 10 days before the next subcommittee meeting to get back. Like,
That seems too optimistic. When is the next one after that? Is the next one after that the 3rd or the 4th?
Yes.
Yeah. So
I think if we thought that by the 4th we were going to have up or down votes on all of the recommendations, so that leaving the 4th we would know what the recommendations are, that would give us a month and a half to put it in writing. That seems okay.
Yep, that was what I was thinking, that we probably needed a month for, that's one cycle for people that have to go back to their like meetings, right? Their regular like board meetings or whatever. So
we could try to use the next meeting as a sort of a general discussion to like answer questions and clarify things, as send people back to their groups on the short turnaround time, maybe start getting some feedback, at least look at things that are confusing or that might need to be clarified, then use that meeting time to do that.
Yep. All right. That sounds great. Yeah, I was worried we weren't going to give people enough time. So I think that's good to have a month. All right. Anybody have any other thoughts or?
Well, we could continue to talk about the process of getting the writing done. I suppose there was a suggestion of a work group. To me, I think it makes sense just because the subcommittees have put so much work into coming up with their sets of recommendations. You know, it seems like it would be weird to ask somebody who wasn't in one of, didn't participate all year in one of the subcommittees to carry the load and writing something. So I guess my suggestion would be that maybe we just leave it to the subcommittees, assign it to the subcommittees that you're going to write up your section of the report.
So I think what John and I talked about is selecting a group to write it, and that it would be a couple of folks from each group.
Oh, okay.
And so, because there's only going to be a couple people from each group that are going to want to do it anyways, Josh. So welcome to the group.
Hey.
And yep. And so, and we can talk about that. Like if there's, yeah. Cause we want it to be clean, right. And crisp. And so like, if there's anybody that feels really strongly differently about that, and, people that have worked on these before, I think the other thing that we could maybe do at the next group, like there's been a couple of these reports that I've seen recently that have been done really well. And they're different. Each of them is different. And so we can maybe look at the couple of them and like the way they're laid out is different. And so we could maybe talk about that a little bit too, and see if people have thoughts and opinions about like the structure of them or whatever. And see if folks have thoughts, and then to give the task to the working group to write it. Because I think too many voices is also problematic. So like to write it, you know what I mean?
As a clarifying question, Madam Chair, are you anticipating this being a formal subcommittee with public facing meetings?
Well, I don't want to make any decisions without John, because I know we've talked about it several times. And so, but I think if I remember right, that was kind of the leaning. And I know Max talked about that as well. He's worked on several of these before, and said that that's kind of the preference. That's easier when it's a smaller group. And so, but I don't like, that's just what we talked about. And so, yeah, so I'm not in charge here. I'm not making any decisions, but I know that was what was talked about prior. So we could make that decision maybe at the next meeting for sure. And I know he has the authority to just like appoint some folks and make a new subcommittee. I'm not in charge.
Well, thank you, Madam Chair. Yeah, the reason I ask is I was just going through the minutes and what's been resolved. If I'm interpreting read the previous resolutions correctly, Chair Geffen has the power to appoint members to existing subcommittees that the task force has created.
Oh, we would have to make one.
Yeah.
Oh.
Which shouldn't be a problem, but like I think that would be a vote for the membership.
Okay. And we should do that now if we're going to do it.
That's up to you, Madam Chair. If you don't anticipate wanting this to be a public facing, this would be if you wanted a formal subcommittee created. There just would be the potential open meeting law issue with a privately circulated document that had comments. We'd want to make sure, for example, to get all those comments aired in the open in a full task force meeting for open meeting compliance, if there weren't a different public facing group.
So I feel like for now, we're going to do it all in the task force meeting with the comments on the recommendations. And then next time, so John has a problem with Fridays though. What are we going to do about that?
So, Madam Chair, between Chair Geffen, so just as an explanation to the members, Chair Geffen's had a scheduling conflict come up that might make some of these Friday meetings problematic. And between that and the fact that we missed 2 Fridays in November due to holidays, One thing I could do is circulate a poll among the members for an alternate meeting date or alternate meeting time to either shift to like for some extra meetings in November or just shift to completely for Chair Gaffney's convenience. Just let me know what you'd like me to do.
Yeah. Yeah, he was like Thursday afternoons. So maybe, yeah, and we can stick to Fridays and I can just get some good guidance maybe from him, but he was looking at maybe Thursday afternoons. And so maybe that's the best way to move forward is for you to maybe send out a poll and see if there's another day and time that works for these last few meetings so that we can keep John at the helm. So, all right. Perfect. Is anything I forgot or missed?
I don't believe so, Madam Chair.
All right. All right. Well, we're going to get it just as a reminder of action items. We're going to get the document out to everybody probably Wednesday next week. And then everyone has until November 4th to bring it back to digest it and then bring it back to their people and get some comments made on a Google Doc that's going to get distributed that Will's going to put together. So, and we'll meet at the next meeting and talk about other stuff. And then November 4th, we'll talk about the recommendations as a group. So thank you everyone for your diligence and for continuing to come and work through this super important topic. Appreciate y'all. And that concludes the October 7th Human Service Background Study Eligibility Task Force meeting. Y'all have a great weekend.
Thanks, Gina.